Hey guys, what's going on? It's your girl, the Legal Beast. Um, it's been very busy around here. I've had very busy court days, and things to get through. And so even though I got the opportunity to watch the trial yesterday, I didn't get a chance to make a video yesterday. And so I thought initially trial um it was like the typical mundane kind of trial initially. They're going through all like basic lay witnesses, who was at the property, the renter of the property, how would they describe it, how would they describe Miss Crumbley's disposition, her reactions, etc., etc. But baby, when they got to the witness, and I'm not saying witnesses' names for a reason, when they got to the witness that she was having an affair with, the show began. Because that is when basically on cross-examination, Shannon went after the witness as being deceptive, and beside being deceptive, but basically attempting to argue that he was threatened by the police because of the multiple interactions that she had, that they had with him. Specifically, the fact that the officers were had more than one visit with him, and then that they were supposedly giving him some information, and she's arguing that they were threatening his employment, threatening his future, threatening to tell his wife, and so then the prosecutor hops up, and baby, this is where it got interesting. Y'all, when that prosecutor hopped up, whoa, Your Honor, I would like to just say that Miss Smith, defense counsel, is now moving to territory of testimony and text messages that have been specifically in a topic that has specifically been excluded by motion of the defense. So apparently in November, I think they said of 22, in November of 22, I'm pretty sure that's what they said, Miss Smith filed a motion in limine, and a motion in limine is a motion to preclude certain things from coming in. Miss Smith filed a motion in limine. When she filed that motion in limine, what she sought to preclude and keep out was all of the extramarital affairs that Miss Crumbley was having, because she was not only having an affair with the gentleman that was testifying, but she was also previously had extramarital affairs with someone else. So it was originally, my understanding is the motion was filed to preclude it so that it would not, have any prejudicial effect in regards to, morality or anything like that when it came to this case for Miss Crumbley. So then the defense attorney jumps up, and defense attorney Shannon is like, Your Honor, we understand. Your Honor, we understand. And if I'm on that door, if I'm opening that door, then I'm opening that door. If that's what the court thinks, then I'm opening that door. And I'm like, bitch, you really want to open that door? Are you sure? You want to convict her already in the trial of public opinion? Now you want to say not only was she a bad mother, but she was a whore? Because that's essentially what that would look like, because she married and sleeping with all these people. Let's just be honest about it. So baby, the prosecutor then is like, well, I think this is a discussion we need to have outside of the jury, because at this point they haven't mentioned anything about what that extra information is. They haven't said that it's about extramarital affairs yet. They've just said that it's been sought to be precluded, and she's opening the door to it, and she's like, bitch, I told you I would. And so the judge at this point gets the jury out, baby. So the jury goes out, and it gets down to it, and Shannon is arguing, I'm the attorney. I choose trial tactic. I've discussed this with my client. If the court feels I'm opening the door, then I'm opening the door. And the prosecutor is like, well, then if she's opened a door, I have the right to rehabilitate on it because this is a topic that she fought to exclude. And so now I can go into it. And so the prosecutor is like, well, if this is what she wants to do, I want this voir dire of her client placed on the record. Voir dire, as Joe Pesci would say. And what is a voir dire? A voir dire is a questioning of the witness or the person, and it's like factual averments that they're confirming A, B, C, D, whatever, and then placing it on the record. So, jury's out of the room. Miss Crumbley, the prosecutor's like, hey, maybe she wants to speak to her client, Your Honor. I think she should have opportunity to speak to her client. Miss Smith is like, oh no. Defense counsel is like, I've already spoken to my client. We've gone over this. She already knows that this is, we've had this discussion and it's trial tactic. To me, says that basically fuck what Miss Crumbley wants. What she's saying is trial tactic is solely within her discretion, and it is per ethical rules and statute and court rule. It's within our discretion. And so what she's saying is, since it's her discretion, she decides whether or not she's opening the door for that evidence or she's going to try and keep that evidence precluded. So the judge asks Miss Crumbley to stand up. She goes ahead and questions her. Questions her about whether or not she wants to, she understands what's going on, and that if her attorney questions a certain way, then this information would be admissible in court, and it would open the door to things that were precluded. And so then Ms. Crumbley is like, well, I would, she's like, well, yes, I understand. That's fine. I guess. And she throws that I guess on the end. And so then the prosecutor's like, Your Honor, that's not sufficient. She said, I guess. We need affirmation that she wants to use this on the record. Y'all. That right there, I'm like, now Shannon is right. Trial tactic and evidence to be submitted and used is within the discretion of the attorney. Now, obviously, you have a discussion with your client about it, but it's still solely within the discretion of the attorney. But the fact that she fought to keep this out, and then on this testimony, on this witness, she's making allegations of basically the police intimidating this witness, saying that they were going to tell his wife, they were threatening his job, doing this, doing that, and he doesn't really say that in the affirmative. So I don't know if she really got what she wanted by opening that door, but that is a hell of a door and a hell of a fucking risk to take when your client is already looking like a bad mother in public, in the trial of public opinion. So now you want to throw that you are a cheating wife and a bad mother together in a trial. Baby. I took just a moment. I wanted to look at something again really quickly. And, I really don't know. With the whole opening of the door into certain testimony and text messages, and I don't think it was worth it, because Jennifer Crumbley testified today. And once the door has been opened to a specific topic, and I haven't watched today's testimony as of yet, but once the door's been opened to a specific topic, you don't get to just pick and choose and say, oh yeah, we're opening the door, but you can't ask this question about that door's open. And I can't wait to watch today's trial because I want to see how that testimony went. But yesterday, that is like, it was mundane until it got to the end, and it was like, hold on, wait a minute. So I hope you guys have a great night. Again, this is your girl, the Legal Beast, attorney Kiana Fralick, coming to you from Michigan. My office is in Oakland County. Michigan, where this case is proceeding. And I can't wait to get to today's testimony so I can talk to y'all about that. Y'all have a good one. Bye-bye.